Who's happy it's the last day? Raise your hand.
No more sitting.
You gotta stand.
Are you happy it's the last day? Yeah. I know you're going to miss us terribly, right?
Just put my lid on. Make it look efficient. Now I look taller.
Oh,
Yeah.
gosh. I know you have to wear the pea cap, right? I like the Stetson, to be honest.
Yeah,
You didn't
well,
like
you're
it?
You're just a little
You
biased.
know,
I know.
yeah.
No?
I like them, no.
You-
Frisbees.
I like them. I think they're cool.
Frisbees.
They were comfortable for short periods of time.
Yes. They were very statesman-like, though.
Yeah.
Like, they were scary. My mom used to say,
Just
Greg,
poor
you look
quality.
scary in that hat.
They should have been felt.
Intimidate, yeah.
Well,
Yeah.
they're made like this RCMP
They're
guys.
made, what are they made of? That's
It's just like a
plasticky,
wicker-
sort of a
yeah,
wickery thing?
yeah, with
Which
all
wouldn't be
the-
good on your melon.
No.
Alrighty.
Oh,
Are we
I'm just
ready?
going with suits.
Are we ready?
Ready? Oh, bookend. You guys have
Okay.
suits.
So, good morning, everybody. I have a few remarks to make, and then, with your indulgence, I'm going to get started, and then we'll take questions, obviously. I'd like to thank you for joining me here today, members of the press, colleagues of the legislature, the Honourable Catherine McGarry, not yet honourable, but always honourable in my eyes. And I'd like to take a moment to introduce some of the special guests with us this morning. Chris Hoffman, Vice President of the Ontario Provincial Police Association. Where did he go? On my left. Bruce Chapman, President of the Police Association of Ontario, on my right, and a Detective Sergeant in Peel. Stephen Reid, the Executive Director of the Police Association of Ontario. Hugh Smith, to my far left, Constable at Toronto Police Service. Teresa DeFelice, Director of Government and Community Relations at the Canadian Automobile Association. Jamie Stuckless, the Executive Director of the Share the Road Cycling Coalition. Thank you, one and all, for being here. I'm pleased to be here today to present my private member's bill, Bill 213, the Highway Traffic Act Amendment, Careless Driving, which I tabled on Tuesday, June 7th, and which will be debated during this afternoon's legislative proceedings. 10 years ago this week, my life and the lives of so many people dear to me changed forever when a careless driver struck and killed my husband, OPP Sergeant Greg Staubert, a veteran of police in his 25th year of service. Greg was killed while on a training ride in Milton on his bicycle. He was 44 years old and in the prime of his life. Greg's death and his life's work as an OPP officer have been the impetus for the direction that I've taken in my life over the past decade. It has shaped my approach to and my decisions regarding advocacy and my decision to fight for changes to legislative constructs for enhanced infrastructure funding for cycling, education and awareness for motorists and cyclists when it comes to sharing the road, all in the interest of road safety. Our response to Greg's tragic loss was, in 2008, to make the case for legislative changes that would enhance road safety by providing frontline law enforcement, like the gentleman you see behind me, with the tools they need to reduce the number of motorists who continue to drive under suspension. This was in response to Greg's case, but also to the estimated 500,000 suspended drivers in Ontario at that time, in 2008, with an estimated 3/4 of these people continuing to drive despite their suspension. Greg's law provided for enhanced penalties for motorists who drive under suspension in the hopes of reducing recidivism, the number of uninsured drivers off the road. It passed in 2009 and came into force in 2010. In 2008, we started the Share the Road Cycling Coalition, a provincial cycling advocacy organization with a mandate to bring about legislative change in Ontario that would enhance road safety, empower municipalities to make their communities more bicycle-friendly, and change the conversation, enhancing public awareness and safety on our roads across the province. The driver who killed Greg had 5 previous convictions of driving with a suspended license, 2 convictions for driving with no insurance, $14,000 in traffic-related fines. His sentence, his license was suspended again, and he received 100 hours of community service. And just 62 days after this man hit Greg, he hit someone else. One of the conclusions to be drawn from this is despite his actions, despite the fact that he killed someone as a result of his carelessness, he continued to drive without the kind of due care and attention, which is the minimum standard expected of all of us, and which the Careless Driving Statute, Section 130 of the Highway Traffic Act, demands. Tragically, Greg's story is not unique. Every year in Ontario, lives are taken because another individual makes a bad choice. In 2015, in the city of Toronto alone, 64 people died in traffic fatalities. This is up from 35 fatalities in 2011 and 51 in 2014. And so, in 6 short years, the number of lives lost, all of them preventable, has nearly doubled. Of those, 38 were pedestrians, 4 were cyclists, meaning that 67% of those were vulnerable road users. And I'm willing to bet, because statistics are not kept in this regard, that a good chunk of those led to charges of careless driving and to outcomes for all concerned, the victims, their families, the police officers laying the charge, that were less than satisfactory from the perspective of some kind of assurance that the penalties associated with the outcomes were insufficient. Of course, when you lose someone you love, like I did, nothing is going to bring them back, and nothing will feel sufficient. But of this I am sure, that the current statute, which lacks the kind of specificity, both in terms of the charge and the sentence provisions, is calling out for reform. Carelessness is the cause of most deaths that result from vehicle-related collisions. These kinds of injuries and fatalities are entirely preventable. According to the 2012 Chief Coroner's Report on Cycling Deaths, of which I was a member, of the 129 deaths reviewed, 100% were preventable. Because all motorists make choices, whether it's choosing to text and drive, choosing to get behind the wheel after a few beers, or instead, hopefully, choosing to concentrate on the task at hand, focusing on the road, and arriving at their destination safely. A police officer friend of mine said once, "Sometimes, Eleanor, there are just accidents." Fair enough. But if your poor choice results in injury to or the death of another human being, if you are inattentive behind the wheel, even for a moment, if your carelessness and disregard for others leads to these results, if Bill 213 passes, the penalties you will pay are significant. By contrast, the person who is the victim of your carelessness, who may be seriously injured, will face a lifetime of difficult challenges, and so will their family. And if you kill them, and the sentence you have imposed is a life sentence, as I know only too well. As police officers know, it's unlikely that these types of collisions, including those causing death, will result in criminal charges and the stiffer penalties that come with these federal statutes. Indeed, most will result in a traffic violation under the Highway Traffic Act. It's far too common for motorists who have caused the death of another human being to see the penalties as simple as fines of a few $100s, demerit points, or a further suspended license. Worse still, as happens so often with traffic offenses, a plea bargaining process ensues with a lesser sentence often applied. And so if we provide officers with the tools they need to lay a charge which speaks to the behavior of the motorist as well as the outcome, and if we provide the courts with greater specificity when it comes to sentencing options with the full force of the highest penalties allowed under provincial statute, then we are sending a clear signal to all Ontarians that driving is a privilege and not a right, that driving carelessly is serious, and that lives matter, especially when the family of the victim is served a life sentence of grief. Under the Highway Traffic Act, careless driving is one of the most serious offenses. It is defined as driving without due care and attention. In order to charge a driver under the criminal code, there would need to be established an intent to kill, or the motorist in question would have to be so outrageously dangerous that the driver would have known that killing someone was a likely possibility. But in cases of careless driving that result in death, unfortunately, that means that most of the drivers are charged under the HTA, the Highway Traffic Act, where the driver's actions are under scrutiny, not the fact that an innocent person was seriously injured or killed. And so clearly there's a gap between careless driving, or the Highway Traffic Act, and the criminal offense of dangerous driving or criminal negligence. Bill 213 seeks to close that gap. Currently under the Highway Traffic Act, the minimum fine for careless driving is $400 and the maximum $2,000. Drivers could face up to 6 demerit points, license suspension of up to 2 years, and up to 6 months in prison, although this is rarely, if ever, delivered as a sentence. Indeed, a friend of mine, a member of the Toronto Police Service with 29 years of service, told me recently that in all of his years on the job, most of them in traffic, with several careless driving charges laid, none of them has ever resulted in a jail sentence, despite the fact that people have died as a result of the carelessness of a motorist. To him, and to all the officers across Ontario who serve our province, who work so diligently to keep our roads safe every day, I say this. In Greg's memory, and in memory of all those whose lives have been lost, for all of the reconstruction officers, the guys and gals patrolling our roads and highways, this bill is for you. Greg's frustration with the lack of specificity inherent in Section 130, his frustration at his own inability to lay a charge which fit the offense, was something I heard about all too often. To see it play out in a case that took his life was shattering. Today we are changing the conversation about what careless driving should mean. This bill aims to fill the gap between less and more serious offenses offenses, providing additional charging options to both law enforcement and to our courts. It aims to recognize and provide a tool for collisions that result in serious injury or death by creating a separate offense of careless driving caused death or bodily harm. Bill 213, if passed, would increase penalties under this new category, making a clear distinction between careless driving and careless driving caused death and bodily harm. It will also give police officers more time to conduct an investigation and collision reconstructionists the time they need to do those often painstaking investigations. Under the new proposed category, fines would be a minimum of $2,000 to a maximum of $50,000. The driver could face a maximum of 2 years in prison, the maximum allowed under provincial statute, as opposed to the current maximum for careless driving, which is 6 months. Their driver's license could be suspended for up to 5 years. Their sentencing options will include the requirement to complete a road safety or a driver training course. Ultimately, the goal here is to have penalties in place that discourage careless driving and encourage good choices behind the wheel, but we will also use this opportunity to help promote public awareness of the threat faced by vulnerable road users. And finally, we will draw attention to the fact that when a motorist is careless and hits a cyclist or a pedestrian, the outcomes are much more significant. And with Bill 213, both our officers and our courts will have the opportunity to send that very clear signal that driving with due care and attention matters, arguably more so when it comes to our most vulnerable road users. I look forward to debating Bill 213 with my colleagues this afternoon. Thank you again for coming. Happy to take any questions.
This sounds like a no-brainer to support it. Have you talked to the other two parties about this? This sounds like something that I think no one could disagree with.
No, and they haven't actually. I'm someone, as many of you have gotten to know me, and it was certainly my practice before I was elected to work across the aisle, and certainly in this case, I'm assured by both sides that they absolutely support this.
So you're confident that this could change? I mean, this wouldn't change in time for this summer.
No, but I asked both Minister Del Duca and our Attorney General and Minister Nakvi. I asked them to carry this through as a private member's bill because the issue is so personally important to me. I could have advocated for, as a government member, that the government passes a government bill, but I'm confident with the support that I have that this will become law in due course, in short order, hopefully.
Is this a change that you've been planning, hoping for 10 years now?
Yes.
You dealt with the suspension a few years ago, and now this is the next step?
10 years and then some. I mean, again, when you're married to an officer and he comes home from work, as any of these gentlemen behind me can attest, the frustration that you have with the inadequacies sometimes of the tools, and as Greg often said, and these guys will attest to, he'd say, I just enforce the law, I don't write it or make it. And I've heard those words in my head so often, and it stayed with me. And so I am doing this in his memory, and I am doing this for road safety and for all the victims, but I'm also doing it for these people beside me who, again, they can't make the laws, we do. They enforce them, but they're frustrated sometimes with the lack of specificity and the fact that careless can sometimes, I call it like a big basket into which most charges fall. And it's like that basket that has no dividers in it. Well, today, we're providing clear delineations that careless remains, but if you kill someone or injure them seriously, the penalties will be enhanced and significant.
When does it become, when would it become a criminal charge then, like a federal criminal code charge? I don't understand why this gap exists. If you're careless driving, if you've maimed or injured something, why isn't there a criminal code charge?
Well, I may ask one of the gentlemen behind me to answer that, Keith, but my understanding is that it's a high bar in terms of evidence. I mean, I was asked recently, actually, by one of the lawyers in our government why the gentleman that killed Greg wasn't charged with dangerous driving, but the evidentiary basis for dangerous is a fairly high order. I don't know if you want to speak to that.
Yeah, just in simple terms, I'm not going to get into the letter of the law, but when you get into the criminal, they have the mens rea of guilty mind, so there's intent. And a lot of times with careless, it was unintentional. There's no intention for that person to have done it. So just by sheer fact of their environment or not paying attention to distraction, somebody got killed or seriously injured, but they are responsible for that. So I always put it, simplified as unintended, and the other one had some type of intent behind it. So that's where we get into the criminal side.
Is that the difference between dangerous and careless?
It's for the criminal. He was asking for the criminal code or under the highway traffic and provincially. So if I have a driving behavior and there's some intent, so it's criminal negligence and cause death or bodily harm, over a careless operation where somebody has had serious injury or died. It could be something as people consider a minor fender bender, a rear ender. There's nothing under the Highway Traffic Act other than follow too closely, where you have to have some type of witness for that. So we'll go with a careless charge because you have to have a distance behind. Doesn't matter what's happening in front. You should be able to stop before you hit it. But I've had people hit minor bumps, and it rolls into somebody else and kills them. Or we've had them where airbags go off and somebody has died. This happened years ago. So we have to look at the manufacturer's thing. But we're not going to charge them criminally. But there should be some responsibility based on that somebody has died. So that's why I said one's intended or unintended, the other one has some type of intent or responsibility based on it that you would have known about.
And if they're drunk, does that mean that that intent is assumed? Or
Well, that's a whole thing with criminal impairment. There's a whole different law on over 80 and impaired driving by drugs and so forth. They have a whole section of the criminal code because, again, in society, it's written that way. No, sir.
Some examples of what could fall under careless driving.
I'll give you one. Again, it's followed too closely, or was one as far as being pled down. So if you've run into somebody, careless driving. Basically, you break it down. It's undue care and attention to the road. Some of our enhanced bills now with distraction, because they give you all these devices that are put into the vehicle, doesn't mean that you should be operating. If you're taken away from the primary task of driving, at any time we can account to that careless unless there's a suitable charge direct for that. But if it's something slighter, usually it's a combination of a couple of things that you're doing in disregard for somebody else's safety, or willfully doing it, and then there's a collision. Then we'll take they're saying we'll take that all together and put it to support the charge of careless. We can get it brought to court where a judge can make a decision based on all the events rather than the singular. And that's why a lot of times it's pled down to one or two charges that are specific to it. But on a whole, we see there was a lot more to it, but we're not there to judge that. We're there to bring forth, there is enough evidence to support more than 2 or 3 charges within that, so we will encompass it with careless driving.
Does this often apply when cyclists and pedestrians as well?
It is. It's greatly so. Again, we look at it from the most vulnerable road user, and something as simple as you might say is crossing the road lawfully. They stepped off, they waited, and somebody whose priority is to make a right turn, and they're looking around because they want to beat the thing there. And I said, well, you got a vulnerable road user stepping onto that road. Your need to get around that corner. So you could say, oh, yeah, it's right turn, not in safety. But I said, no, this pedestrian clearly was waiting there, waited for the actual light to change, stepped off, looked both ways, and this person ran around on a right turn. I wouldn't charge that person with the right turn, not in safety. I would look at the entire event and what was happening, the circumstance, and the time of day, and the vulnerable road user. It's not a car making a left into the left. It's a vulnerable road user, not protected. I would charge that person with careless.
How, your thoughts on how much of a difference this could make, what kind of a difference this could make? Is it sort of like a deterrent?
Well, there's a deterrent. There's always a deterrent, and you look at over the last few years, the government has really pushed forth a lot of enhancements to our bills, given into like say 2009, when this whole thing with distraction came in as awareness and education, and it wasn't until we really started to put some higher fines and demerits that we start to change that behavior, because it wasn't the laws at the time weren't working on a whole. We were still having people making those poor decisions. So with careless, a lot of times, or with this bill, I'm hoping, it provides clarity. If people aren't sure where they fit in, if it's not sort of spelt out and there's no degree or a fine or a penalty, and they're saying, well, we got to remember the Highway Traffic Act was basically written in the 1920s, and it was written in regards to, how vehicles and people moved back then. But it wasn't really written for how, society moves today. With all these types of distractions, with all these mobility devices, with technology moving forward, it takes time to see that degree of just using an iPod or some type of device and not looking away or at the road for about 3 or 4 seconds, that you could kill somebody. But nobody would think of that years ago in the 1950s or 60s when you had a radio that had 2 stations. You push the button and that was it for the rest of the drive. But you have so many factors internally, externally that are happening, and the laws have to reflect that. So the deterrent will hopefully it'll help as far as making a better decision, but we don't like to have to change somebody's behavior in regards to enforcement on that side.
I think Bruce
Yeah.
wanted to add to that.
I'll just
Thanks.
add to that comment. There's nothing more troubling as a police officer investigating an accident where a person is killed or injured, and then having to go tell the family about those injuries. So you talk about deterrence. This will add to, hopefully, as a deterrent to those drivers from texting is another prime example of careless driving. So by introducing this bill, it gives some teeth to the police and hopefully some help those victims and their family in the grieving process as they go through it.
Yep, that's the intended effect. Yep. Good, everybody? Thank you. Thanks, everyone. Appreciate it. These folks will be here for a bit if you want to ask any questions or interview folks in the hall or whatever works. Thank you for coming.